Welcome to our legal planning seminar for adults 55 and over. Today's seminar is a program of the Living Well Network in Cambridge, part of the organization formerly known as the Agassiz Baldwin Community. We serve residents from kindergarten and up. The center is a place that nurtures individual growth, connectivity, builds creativity, and serves as a forum for community advocacy. Our organization, the Living Well Network, fosters a strong, connected, engaged, and healthy community of residents 55 and up. We offer programs to engage the mind and the body. Even during the pandemic, we've continued to offer yoga and meditation classes, a wellness sampler, which we'll be repeating soon, and now a weekly exercise walking group. We have technology support for members and look forward to reopening our technology drop-in center, hopefully in the fall, maybe sooner, and restarting our technology classes. We publish a weekly newsletter of events and information to keep you connected and engaged. If you haven't been receiving our newsletter, if you found out about the event some other way, you'll receive our next one next week, and then you can decline to continue to receiving it if it doesn't seem helpful to you. Today, I'm pleased to welcome 3 attorneys who've agreed to address matters of advanced legal planning for our members and members of the community in Cambridge. They are Rosemary Wilson of Sullivan and Worcester, who'll discuss documents for advanced planning. Hello, Rosemary.
Hello.
Jennifer Taddeo of Con Kavanaugh, who'll present a brief introduction to probate, trusts, and ways to transfer assets. Hi, Jennifer.
Hi, so happy to be here.
And finally, Sarah Hartline of Margulies and Bloom will provide an overview of Medicaid. It's really wonderful to have the 3 of you. I thank you for doing this for us today. And it's wonderful to have all of you who've joined us as well. Here are a couple of reminders, please, for the participants. Please keep your microphones on mute. Our attorneys are going to answer your questions at the end, beginning with some of those questions that some of you sent in advance. So please save those questions. However, you can write them in the chat. At the end, after we do the questions that were sent in first, I will look for questions in the chat and recognize the questioners there. We have a lot to cover today, so I'm going to begin with Rosemary Wilson. Rosemary is an experienced, and I'll take this, let's stop that sharing now. Rosemary is an experienced trust and estates lawyer who's concentrated on the court interface with the states. But she has especially enjoyed assisting clients in planning decisions, both for lifetime circumstances as well as after death. So Rosemary, I am going to turn this over to you.
Hello, everybody. I'm delighted to be here. And I know that all of you imagine that you will go through life until the day you die, perfectly competent and under control and taking care of all your affairs. But unfortunately, that might not work out quite perfectly. And so I'm here to discuss some of the things that you should really think about in the event that things don't go as you would wish. First of all, you need to decide what your own wishes are with respect to how your finances are managed and what your healthcare decisions are. Next, you need to decide a person to delegate some of those decisions to in the event that you are unable to take care of them yourself. That's a very tricky part, is figuring out who would be the best person, for example, to take care of your finances or to deal with health decisions. And of course, once you decide what your wishes are, you need to discuss them in great detail with the person that you name. Now, there are 2 main categories of affairs that need to be taken care of. One is your financial life. And the document that you need to rely on in that arena is a power of attorney. And I know that you frequently hear it called a durable power of attorney, which simply means that it is applicable even if you lose capacity. So whenever you find a durable power of attorney that you might want to use, do check to make sure that it's durable. However, the day you sign it, it is effective. You can also name an alternate just in case the first named person is away or unavailable at the time the situation arises. And I would strongly suggest that you educate your attorney in fact, which is the name of the power of attorney, that you educate them about your finances, because the power of attorney will give that agent or attorney in fact powers over all kinds of things, not just bank accounts, but also your investments, your real estate, your retirement plans, and even it will give you the power, the attorney in fact, the power to name a legal representative just in case you end up needing a conservatorship. We are hoping that a durable power of attorney will avoid that necessity, because any intersection with the probate court is generally pretty cumbersome and doesn't work nearly as well as a durable power of attorney. You might wonder in what circumstances a power of attorney would end up being used. And one is being 55 plus. You might have just gotten sick of doing some of the things that are like figuring out your cell phone coverage, your homeowners and things, and sort of like cooking Thanksgiving dinner. You've done it, maybe somebody else's turn. However, but if that's the case, you should simply educate your attorney in fact in terms of the way that you have done things and the way you like doing things. Another way it might arise is if you want to spend the winter in Arizona or something, leave somebody in charge of your financial affairs here. And another, of course, is if you do lose capacity, you will then, either pay bills twice or not at all is usually one of the indicators that you're no longer capable of handling your financial affairs. And at that point, the power of attorney will step in. It's important if you do most of your financial transactions with one institution, like Bank of America or Fidelity, that you tell them that you want a power of attorney, because sometimes they're fussy and only will honor one that's within their parameters. So you can do that. So your attorney, in fact, can carry on taking care of your stuff until the end of your life, but it ends on the day you die. So one thing that frequently comes up is people want to pay for the funeral. And how do you do that? There's no access to the money anymore. So in those circumstances, I would suggest that you deal with it in a different way. You can either prepay the funeral, or you can set up a separate account or use a revocable trust just in case you have one. So that's the financial side of things. On the physical care, there are two main documents. One is called a healthcare proxy, and the other is called a MOLST. The healthcare proxy names an agent to take care of your healthcare decisions if you were deemed by a physician not to be able to take care of those decisions yourself. Now, this kind of situation classically comes up if you're in surgery and there's a fork in the road and a decision has to be made, and your healthcare agent can make that decision. But when you come to after the surgery, the power to make healthcare decisions reverts back to you. So under those circumstances, again, it does come up at end of life issues. And these are very, very tricky issues. And families tend to be in a state of high turmoil at that point. And so it's extremely important that you have named somebody to make your decisions rather than having it a group effort, which sometimes doesn't work out too well. And and you have to make sure that the person that you do name is appropriate in terms of their personality to make difficult decisions, carrying out someone else's wishes rather than their own. The other document is a MOLST. And this document's gotten very popular recently and is in effect a contract between you and your doctor to either carry out certain procedures or forego certain procedures under certain circumstances. Very frequently, a MOLST is created by the doctor and patient when the patient is already in pretty fragile health. So the patient is worried that they're going to collapse in the kitchen and the EMTs will come and revive them, and all that will not be in accordance with their wishes. So if this is the case, you should enter into a MOLST agreement with your physician and then photocopy that onto Day-Glo paper and put it on your refrigerator or carry it around with you if you're outside. And so if EMTs do come to your house or you collapse in the street, then you are in a situation where your wishes will be carried out. It is, excuse me, it's more of a specific contract between you and your doctor, but that can be carried out by physical care workers, either a doctor or EMTs or otherwise. So it's very, very important in all these situations that you name a person that is appropriate for the job and that you tell everybody you know what your wishes are. And that way you are most likely to have them carried out. In addition, there are other documents that make life easier at the end of your life, and that is decisions about cremation or where you want to be buried. And all these things just need to be discussed with your inner circle, whoever that is. So I don't know whether I have used up my time or not, but I'm willing to cede it to the next speaker.
Kathy, you're on mute.
Thank you very much, Rosemary. Somebody just joining. And this is, you see before you, Jennifer Taddeo. Jennifer is an accredited estate planner, and she's a partner at Kahn Kavanaugh, which is a 35-lawyer general practice firm in Boston. She concentrates her practice in estate planning, tax planning, business succession planning, and trust and estate administration. She tells us that when she's not busy helping clients, she can be found supporting her community at the Vernon family branch of the Hockomock area YMCA. And so I am going to ask Jennifer to Jen to take over. Thank you, Jen.
Thank you. Well, I'm really happy to be here with you all today. And I have to tell you, I have 10 to 12 minutes and I could talk with you all for hours, as could each of the three of us. I think you'll find that with estate planning attorneys, you don't get the prototypical attorney who hates their life, but you have people who are passionate and love what they do. So we could talk your ears off. So thank you to everyone who's giving questions so we can really tailor it to you. What I've been asked to talk with you about today is how do assets even pass from one person to another? Because so many people come to us and say, oh, I've got a will, so I don't need to worry about probate, which has so many wrong things in there that we want to get at the basics. How do things pass from one person to another? What is probate? So why do we even worry about it? And then how do we eliminate it if that's what we want? And we'll touch upon the Massachusetts estate tax. So first, I think of assets passing, I have teens, but Sarah, who you're going to hear from next, she's got little ones. So it's like when she says, okay, everything's got to get cleaned up in the playroom, it all has to go into one of the buckets. Same thing with your assets. They all have to go into one of the buckets, and there's 3 of them. You have assets that pass by operation of law, you have assets that pass by a contract or contract-like arrangement, and then you have probate. So the assets that pass by operation of law, those are the assets that you own jointly with another person. And you own it in a way that it's not what we refer to as tenants in common, but with a right of survivorship. So if one of you passes away immediately, the other one owns it. This is very common among spouses. It is something that a lot of people use as a way to stay out of probate by just adding a friend or a sibling or a child on as a joint owner, and it can cause you a lot of trouble because it can make for uneven distributions. It can make for having to fight off creditors saying that the joint owner should be able to access it to pay their debts. And it can raise questions about, are you making a gift right now? So I don't love assets being owned jointly during your lifetime unless you're married to somebody. That's a really broad statement. And there are a lot of situations here where we're going to make broad statements, and you working with your estate planning attorney who knows your specific situation may come out to a different decision. And that doesn't mean it's wrong. It just means you have more information available. So assets you own jointly, great. First, as soon as you pass away, the other person owns them. No process is needed. You probably have to show a death certificate, but that's it. Then you have assets that pass by a contract or a contract-like arrangement. This is when you take an asset and you turn to some entity and you say, okay, you're going to hold this for me, and here are the rules about what you're going to do in the meantime, and here are the rules about how it's going to get paid back out to me. The common things that people have in this category, anything with a beneficiary designation. So your life insurance, your retirement accounts, that was my first 3-minute mark, your retirement accounts, where you've said, okay, I'm filling out this form, and this is who is, so I'm seeing the note that there's difficulty with the audio. Is everybody having that, or is it, no, okay. So the person who said that, I'm happy to chat with you later. But so anything that you put a beneficiary designation on, you've told them, here's how to pay it out. Then we have assets. So that's also assets that are going to be owned by a trust. All that a trust is, it's a set of babysitter instructions. It's a way of saying, if I can't manage this asset because I've died or I'm incapacitated, here is how, the mic is actually in my ear, so I can't get any closer. But here's how it will pass. And sorry. So you create a trust, a set of babysitter instructions, a way of saying, if I can't manage it, here's how I want it managed. And when we say you create and you fund a trust, we just mean you write out the instructions in the appropriate legal way with your attorney. I will do my best, Judy. So you could write it out with your attorney. You sign it with all the proper formalities, and then you fund that trust, which means you actually take your assets and transfer them to the trust. So the trust becomes the owner and not you individually. If that happens, then upon your death, whatever the trust says, that is what is in charge. That is what says who gets the asset. So either you've made your assets joint and they pass to the joint owner at your death, or you've created a contract or contract-like arrangement where you have a beneficiary designation or a trust owns it that has instructions, or you own an asset individually with no beneficiary designation. And that is going to be something that goes through probate. So what is probate? Why are people working so hard to stay out of it? Probate is just a court process that provides some oversight to make sure that whatever you say in your will is actually what happens. All right, so then why do people work so hard to stay out of it? It's a process that's designed to give us some certainty and some finality. It's a process that's designed to find any conflicts that are out there, pull them forward, and resolve them. And so as a result, it's designed to be slow and long and public. It can be months before somebody's appointed as the personal representative. It has to stay open for 1 year because creditors have that long to come forward with their claims. And everything is a matter of public record when you're going through a probate. So why, people say, well, why would I go through this? Well, sometimes that is the simplest thing to do. You have a will that sets out who is in charge and who gets the assets. Sometimes people don't have a will and they still have assets in this category. That means it would go through what's called an intestacy process, where the Commonwealth of Massachusetts has done your estate planning for you. And they say, just based on your relations, here's who we would favor for being in charge, and here's how the money would get distributed. So if you choose to do a will, you're still going to go through the probate process, but you're overriding the default estate plan for that the Commonwealth has done for you. So you're saying, we want this personal representative, the person to shepherd the estate through the probate process. And at the end, I want it to go out to this person or these people. So as I said before, sometimes we decide to stay out of probate by making things joint, by putting a beneficiary designation on, or by creating and funding a trust. And one thing I did want to talk about, the trust can say whatever you want. You have to work with your attorney to determine what's appropriate for you. You would go to them with your ideas about what would be appropriate, and then they can help you figure out what the best way is to actually accomplish those goals. And Sarah's going to talk about what if you have a beneficiary with some special needs. Now, the personal representative, it can be anybody. It can be a beneficiary. It does not have to be a resident of Massachusetts. It used to be, or you had to file some other forms. It can be any person who's organized and detail oriented. That's who you want to choose. And if they are a beneficiary and there are other beneficiaries, they're going to have a fiduciary duty to make sure that all of the beneficiaries get what they are entitled to. So the personal representative will keep records. They will put together an inventory of everything in the probate estate, and then put together an accounting of what was spent and how they propose distributing it. So that is a way for the different beneficiaries to make sure that the personal representative is doing an appropriate job. The last thing I did want to touch upon is the Massachusetts estate tax. And most of us know we have a federal estate tax, but right now it's $11.7 million. I'm not personally terribly concerned about it. So maybe some of you are, and any of us would be happy to help you if that's the case. But more and more people see that federal estate tax as something that doesn't really impact their lives. But in Massachusetts, we do have only a $1 million exemption, which is still a lot of money. But when you think about the amount of the value of real estate here in Massachusetts, it is very easy to hit that $1 million mark, particularly if a spouse leaves everything to their spouse, passes away, and then the surviving spouse has got all of their assets. Federally, you're allowed to give your spouse whatever part of your exemption you don't use at your death. And then they have theirs plus yours. We don't have that in Massachusetts. So if you leave everything to your spouse, at the second death, it's just that surviving spouse's $1 million estate tax exemption. It is a bit of an odd, the way that we calculate it is a little odd, but what is important to know is there is a $1 million threshold. So as soon as you have what we call a gross estate of over $1 million, what that means is you don't get to deduct your mortgage. You don't get to deduct your debts and the expenses of the probate. You have to file an estate tax return. Once all of the debts and expenses are deducted, then consider it to be about 10% of everything over $1 million. That's a rough rule of thumb. It's not exact, but it will let you think about what amounts you're talking about. And one thing I do want to make clear is we talked about how to keep things out of your probate estate. You make them jointly held, you put a beneficiary designation on them, you have a trust own them. that does not mean that they're outside of your taxable estate. And it can be really confusing because estate planning attorneys tend to just talk about the estate. You have to stop and think, well, wait, Jen or Sarah or Rosemary, tell me, are you talking about my probate estate or are you talking about my taxable estate? Because they are different. You can have everything out of your probate estate and still have to file that tax return. All right, I do apologize for being quick at the beginning. I know that I was stressed out by the time. I hope that I was able to clarify some of those initial issues, and I look forward to answering more questions at the end.
Thank you very much, Jen. I'll talk to you in between. We'll see if we can improve your audio. So finally, but not least, as we say, I would like to welcome Sarah Hartline. Sarah is an estate planning attorney with Margulies and Bloom. She's been with the firm for 8 years and lives in Arlington with her husband and 2 young sons. She meets with her clients at her office, at their homes, and now virtually in Zoom. And I have to say that Sarah also introduced us to Jennifer Taddeo and has previously done another seminar with us. So thank you and welcome again today.
Thank you, Kathy. I'm very excited to be here, and I am excited to wrap up the program with a discussion on Medicaid and Medicaid planning. So let me just pull up. I have some slides that, see if I can. Do you see that, everyone? Yes? Perfect. Okay, great. So yes, so I'm going to be wrapping up the discussion with a little bit of information on Medicaid planning and long-term care. And so I think a great way to start is to ask the question of who pays for long-term care. And when I talk about long-term care, I'm talking about nursing home care and also care at home. Having a home health aide, for example, come into your home to provide long-term care. And there's a common misconception that Medicare will cover these costs. And unfortunately, that's not the case. Although Medicare will often cover the first 100 days of rehab, for example, if you're being transferred from a hospital to a skilled nursing facility. In general, Medicare is not covering your long-term care bills. So what are the options in terms of how do people actually pay for long-term care? And generally, I say there's usually 3 options. The first option is to pay privately, of course, so paying out of pocket. Right now in Massachusetts, the average cost for private pay is about $130,000 per year. But we certainly have clients who are closer to $250,000. So we're looking at somewhere around that range in terms of the cost at a skilled nursing facility. The other option is to use long-term care insurance. So certainly this is going to depend on the policy that you have, on the type of coverage, but long-term care insurance is certainly an important tool in terms of paying for part or all of your long-term care costs. Finally, the third option, because long-term care insurance is not always an option, and at a certain point, it's often becomes too late to purchase long-term care insurance, or it might be an issue of just not being affordable at any point to purchase long-term care insurance. The third option is for Medicaid to cover the cost of long-term care. So if you qualify financially by being under a certain threshold in assets, Medicaid will pay for 100% of the long-term care costs. However, you have to get under that very low asset threshold. So what you end up with is a situation where you do have this huge gap of people in between the people that are able to comfortably privately pay for long-term care for a long period of time, and a gap between those people and the people that are already qualified for Medicaid. You have this large group of people in the middle that are in between. And that's where Medicaid planning comes in, because people are starting to think about at a certain point, if I do need this long-term care and I do need long-term care, insurance is not an option and private pay is not a long-term option. How can I smartly, do the spend down under these limits in a way that makes sense? And is there a way to put aside assets for a spouse, for example, that's still in the community, or to preserve real estate for a child? So those are some of the things that you're thinking about when you're thinking about Medicaid planning. And I think it's important, again, just to emphasize that Medicaid covers both care at a skilled nursing facility, commonly known as a nursing home, and also covers care at home. We're very fortunate in Massachusetts to have a lot of community care programs or waiver programs where somebody who would be eligible to receive care at a nursing home but chooses to instead receive care at home, that can be paid by Medicaid or Mass Health, which is the name of the program locally here in Massachusetts. So we have some great programs, that sort of thinking being that most people would prefer to be at home if possible, and then it's more cost effective for the state to provide these programs in your home. However, just to add, there are slightly different, which I'm going to talk about, slightly different rules for those two different programs. However, in general, when you're looking at the asset and income limits, you're looking at, for an individual to qualify for Medicaid to pay for your care, under $2,000 in assets for an individual. So obviously a very low asset standard, or $130,000 for a couple. So that's in a situation where one spouse needs care paid for, but the other spouse does not. You have $130,000 between the two of you. And in general, that does not include your primary residence. For income, there is no income limit for Medicaid in terms of if you're getting care at a facility. However, your income is generally assignable to the facility. So that's, your pension and your Social Security. For the community programs, there are income limits. It's generally around $2,500 a month, but there's a deductible if you're over those limits. The last important rule to think about is that there is a 5-year, what they call the look back period for transferring assets. So if you transfer an asset to a child or another third party, and then you apply for Medicaid and it's been less than 5 years, they may determine that to be a disqualifying transfer, and that might need to be reversed. So that's something that when you're thinking about Medicaid planning, there's usually people are talking about the 5-year look back period or starting the 5-year clock. Currently, there is a 5-year look back period on the books for community programs, but it's not enforced. So again, that comes into the planning and decision-making process. So when I'm working with clients on Medicaid planning, we're typically doing two different types of Medicaid planning. We're either doing advanced planning, which is people that are coming to us to say, my spouse, a family member, we're concerned about this person needing care, maybe in the next 5 to 10 years. What are some advanced strategies that we can do in order to protect assets from a potential spend down for Medicaid? Can we transfer assets to an irrevocable trust or to a child? Can we do something called a life estate deed? There's also a tool called a will with a testamentary trust, which might be incorporated into their estate plan. Those are all advanced planning, things that people are doing well in advance of actually needing long-term care. The other side of our practice is emergency Medicaid planning. And that's when somebody comes to me to say, my father, for example, is going to need nursing home care next week. He has, X amount of assets and Y amount of income. I'm concerned about what my mother is going to be able to live off of and what's going to happen once we start spending down the assets on care. And there are some special transfer exemptions that they might be looking into, such as transferring assets to a pooled trust or a special needs child, or doing something called a Medicaid qualifying annuity, which is a way of increasing the amount of assets that that the spouse, the community spouse, can hold on to. Those are all types of emergency planning that we also do. So an important question, I think, in relation to this is, who is Medicaid planning? So if you've ever heard people talk about Medicaid planning, you'll often hear people on one side or the other. They'll say either, you know, everybody should be Medicaid planning, everybody should be putting all of their assets into irrevocable trusts, which I don't agree with. Or you'll hear people on the other end that say, you know, nobody should be Medicaid planning. And often that's wrapped up into some misconceptions in terms of what it means to be receiving Medicaid and whether, you know, there's certain Medicaid facilities and certain non-Medicaid facilities. There is some truth to that, but there's also a lot of misconceptions that go around about what that means being on Medicaid or not on Medicaid. So the people that, you know, and so I'm somewhere in the middle in terms of saying, you know, it's not for everybody, but for some people it does certainly make sense. The factors that I usually look at for people is their age, their health, medical history, likelihood of actually needing long-term care in the next 5 to 10 years. Is long-term care insurance an option? I always tell people to at least look at long-term care insurance as an option, to look at if there is an option that makes sense in terms of the premiums and the deductibles. You know, long-term care insurance can be, it's very flexible in terms of there's different structures and different ways that you can structure it depending on the person. So that's something worth at least looking into. And then also, what does private pay look like? So if you are going to private pay, say you did have to private pay for care in 3 years, how quickly would you be going through your income and your assets? And what would that look like? The final two factors, liquidity issues. So particularly, you know, I have clients where they own a piece of a family farm. That's going to be an issue in terms of spending that down. They certainly don't want to be in a situation of forcing the family to sell the farm if they own a portion of it. So that might be another reason that you may be looking into doing Medicaid planning sooner rather than later. And then finally, family dynamics. So anytime you're transferring assets, you want to be thinking about whether it actually you feel comfortable with somebody else having ownership over one of your assets. So those are some things to be thinking about. Finally, I'll quickly wrap up because I know I'm out of time. Just some Medicaid traps or things that I hear from my clients all the time about things that they wish they had known or wish they had done differently. Relying on nursing homes for Medicaid eligibility or financial advice. I work with lots of nursing homes. There's lots of wonderful nursing homes and wonderful financial offices there, but they're not the best people to be talking to in terms of Medicaid eligibility. Their incentives are not the same lined up with you or with your family members who are needing care. And I do have situations in which people have received bad advice. Then finally, just anytime you're gifting assets, paying family members for care or other expenses without a contract, any situation in which parents are moving in with a child or jointly purchasing real estate, those are all situations where not only should you be thinking about potential Medicaid complications, but also for tax purposes as well. It's definitely worth at least talking to an attorney to have that initial call to see if there are some red flags or things that you should be aware of. So I know that was a lot of information and in a short period of time. We have, this is my firm's, my email address and my website. Our website has a ton of different guides and information about all of these different topics. So feel free to go there if you want more information, and also feel free to email me or reach out to me to talk directly. Thank you very much.
Thank you. Oops, that didn't go through. Thank you, Sarah, and thank all of you today.
Oh, I think
I've removed your spotlight, but you're still on it, and I don't know why that is.
Oh, I want to, okay.
There's always a technical problem. So I'm going to spotlight myself and kick you off. There we go. So we have a group of questions that folks have asked in advance of our session today. So we're going to go through those first. And a couple of additional questions have come up in the chat, and we're going to try to get to those. And as people are thinking and listening, please feel free to add additional questions to the chat. I will say that you should all have received, with the reminder email that came out just before the sessions, some attachments. We have one more attachment. We're going to send you the PowerPoint that Sarah put up. So we'll send that in a follow-on email, as well as contact information for Jen and Sarah. Rosemary is no longer accepting new clients, so we won't share her information around. We'll just thank her. Okay, so let's start with some questions. The first question, and nobody claimed this, so I'll let the three attorneys unmute themselves so they can respond as need be. The first question is, do different states have different rules governing trusts?
I'm happy to take this one. Yes, estate planning is very state specific. You should have your estate planning done by an attorney who is experienced and admitted in the state where you live. I know that here in Massachusetts, we frequently have people who maybe spend part of the year here, part of the year someplace else. That's a conversation you should really have with your attorney and your accountant, because there's a lot more to where you're resident than half a year and a day. It's much more detailed, much more fact specific, and you want to make sure that you're telling the full story of that you're a resident. Usually you want to be in Florida or someplace without an estate tax. But so all of these documents really are state specific. That doesn't mean you always need to start from scratch. If you have an estate plan here in Massachusetts and you move to another state, you want a local attorney to review everything. And they may only adjust some pieces of the trust that are state specific. The other documents are much more state specific and will probably need to be replaced.
Great. Thank you, Jen. So my next question is, I think, a common desire of many people, which is, how do you make sure that your estate passes to your children and less in the Massachusetts death tax? And I forgot to say at the beginning of our Q&A session that our attorneys are giving general legal information, but not specific advice to individuals. So which of you would like to take that on?
Jen, do you want to do that because you
Absolutely. So estate tax planning, when it's appropriate, first of all, the easiest way is if you are married, you and your spouse, if you plan well, collectively can transfer $2 million without any tax. If you're not married, having a revocable trust is not actually going to do anything for your state tax situation. You might use it for other reasons, like staying out of probate or providing your beneficiaries with creditor protection. But it's not going to, in and of itself, reduce your estate tax. Yes, so the question is, please clarify what amount of money is taxed even if you have a trust that includes a residence. Your taxable estate for Massachusetts is every asset that is under your control at the time of your death, including your residence, including anything that is owned by your revocable trust. So it is going to include all of that. You can choose to make gifts during your lifetime that, depending upon what type of gifts, whether they're what we call annual exclusion gifts or whether they're larger gifts, they may still be considered at your death when you're looking at whether or not you met that threshold, but they won't be in your taxable estate anymore. So reducing beyond saying if you're a married couple, having the reciprocal trust is really good, reducing your Massachusetts estate tax burden is really specific, and you're going to need to talk that through with both your financial advisor, because your cash flow is important, and your estate planner.
Thank you. So Sarah has offered to take this next question. Is long-term care insurance worth it, available to everyone, and how much does it cost? Can you suggest any books that would be helpful?
Sure. So, so I don't have any books specifically. I do have, we do have a few articles on our website about long-term care insurance and some of the factors to be looking at when you're choosing a policy. The thing about long-term care insurance, which I sort of touched on in my presentation, is that it can look like, the policies can look so different in terms of the coverage. Is it covering home care? Is it covering care in a skilled nursing facility? What is the deductible? What is the coverage per day? And so you can really, tailor the policy in ways to keep the costs very low. Or you can, if you're going for wanting something, which of course, ideally you want something that covers all of your costs, no matter where you are, and covers it, costs indefinitely, it's going to be very expensive. And so it really is a situation where, without knowing what somebody's assets and income are, it's hard to make any type of impossible to make any type of recommendations. I mean, the reasons why people don't buy long-term care insurance is, one, affordability, because ultimately you need to be able to afford the premiums, and two, concerns just in terms of the stability of the long-term care, insurance industry. And, when you talk about what's the best time to buy long-term care insurance, a lot of the times, people will say like around 50 or your 50s. But of course, you might not need care for another 30 years, and that's a long time away. And we really don't know what long-term care is going to look like in 30 years. So, so I would say that's a long way of saying, I think everybody should at least consider it. Everybody should at least, run some numbers and look at their situation to see what it looks like, see what the cost would be. But ultimately, it's going to depend on your situation, and it's also going to depend just in terms of your risk tolerance, and are you planning for just avoiding a catastrophic situation in which your long-term care completely bankrupts you, in which case you could get a policy that maybe has a very high deductible up front. Or if you're in a situation where you wouldn't be able to really afford that, then your policy is going to look a lot different. So, so I can put either a link in the chat, or feel free to send me an email and I can send you some of the PDFs from our website that talk a little bit more about long-term care insurance.
Thank you. Okay. So now we have a complex question, and I'm not sure who is going to want to take this one on. It is, what are the financial and tax differences between trusts and inheritances regarding real estate, IRAs, 403Bs, Roth IRAs, and bank accounts that you would use to maximize an inheritance in Massachusetts? Which of our attorneys would like to volunteer for that one?
I'm happy to.
Yeah, I think Jen already touched on it a little bit, but if you want to continue.
I think the important thing about that question, I think, is that it does something that a lot of us do. It mixes together two different taxes. And I think it's important for us to remember there are two completely separate tax systems. There's income taxes, and there are gift and estate taxes. And it can get very confusing. So the reason I say that is, while you didn't say income taxes, the use of the IRAs, the 403Bs, the Roth IRAs, those are things that people are usually talking about the income tax implications of it. And there are a whole set of income tax implications. In terms of estate taxes, it is pretty simple. What you own or have control over at your date of death is included in your taxable estate. And obviously a lot more nuance to that. It doesn't really matter what type of asset, but if I pass away with my home that, say, is worth $500,000 and a $300,000 mortgage on it, a life insurance policy for another $500,000, and a retirement account of another $500,000. My taxable estate is going to be, for the threshold purposes, is going to be 1.5 million, because I've got 500 of a home, because again, threshold purposes, we don't care about the mortgage, 500 of the life insurance, which life insurance, while it is frequently said life insurance proceeds are tax-free, that means what's unsaid is life insurance proceeds are income tax free, but they are includable in the estate of the person who had control over the policy right before they died, and 500 in retirement accounts. So I have $1.5 million. I have to file my estate. Well, I don't have to. My PR is going to file my estate tax return. They get to deduct that $300,000 mortgage against my house. They get to deduct any expenses that I had, any expenses of my final illness, any expenses of my estate, outstanding debt, and that will give them a number. And let's say it's 1.1 million, using our rough and tough 10%. We then have 10% of that 100,000 over the $1 million. So that's how the estate tax side of it would work. And I think the other ones are more about minimizing income taxes.
Jen, you just referred to the personal representative, and we had a question earlier. Can the personal representative be a beneficiary?
Yes, they can. And they would just have a fiduciary duty to all of the beneficiaries. So they would kind of show their work. They would list out what was in the estate and what debts were paid when they're figuring out how much everybody gets at the end.
Great. Thank you. So our next question, Sarah has offered to take on, which is, how do I find a trustworthy person or institution to serve as my power of attorney for my financial affairs should I become incapacitated? I don't have any relatives or friends who want to do this. Who decides if I'm incapacitated? And finally, to whom should I give notarized copies of my advance medical directive?
Sure. Okay. So I'm going to start. Okay. So starting just with the idea of who to choose to serve in this role. So, yeah, I mean, I do have another what's called the organization called NALA, which is the National Academy of Elder Law Attorneys, does have a list with resources on it for attorneys, banks and other financial institutions that are willing to serve in fiduciary roles, whether it be as attorney in fact or as trustee of a trust. Sometimes when people are choosing a professional fiduciary, they prefer to have assets in a trust. It makes more sense, and then have a trustee appointed as opposed to a power of attorney. But regardless, there's a website which I can send that link to Kathy to distribute out. I know some attorneys do that as a service to their clients. They're willing to serve in those roles. Yeah, I mean, beyond that, I do think that, I guess in this situation, it sounds like the person has specifically asked friends and family members and they've said no. But I do have a lot of situations in which people will often say that they just feel bad about asking a friend or a family member. Sort of my typical response to that is that if you say it is sometimes it will be like a niece or a grandchild, and they will feel bad of putting that burden on them. But in the event that somebody is not chosen, in the event that you don't appoint a healthcare proxy or power of attorney, typically there are going to have to be there will be some type of a court proceeding, a guardianship conservatorship proceeding to appoint somebody. And often what I see from that side of things is that the relatives, whoever whether it be the niece or other relatives, do need to get back involved and do end up getting involved. It just ends up being a much more cumbersome process. So I mean, those are some of the resources in terms of people to ask, is maybe to even have the conversation. If you haven't had for the conversation, people are often surprised that people are willing to serve, whether it is a friend or a relative. I think Rosemary had some suggestions just in terms of people in the community, building relationships in the community, that there might be other people in your community that might be willing to do that. Those are some of the thoughts. And then in terms of the question about what happens if you don't, answer that in terms of there would have to be a guardianship or conservatorship proceeding, either brought by a friend or a relative, or in some situations it's brought by a hospital or a nursing home. And then the third question, I think, was, what was the third question?
The third question was, to whom should I give notarized copies of my advanced medical directive?
Yeah, and so in terms of the healthcare proxy, I usually tell people to that they can usually, after it's signed and executed, they can often send it to, they can contact their doctor's office, and they can often scan it into your, now everything is often electronic medical files, and they'll have a way of scanning it into your file. So if something happens, they'd have it ready. If you do have a healthcare proxy, depending on the relationship, it may make sense for them to have that, certainly have that as well. Yeah, those are the two things that I typically recommend for the healthcare proxy, would be the doctor and then the agent as well.
You know, I've also been encouraging people to keep a copy in the glove compartment of each car. If there are multiple homes, keep a copy at each home. And particularly over this last year, I talked with a lot of my clients about, okay, find out how, like, have somebody help you, but create an icon. I know mine's very messy, but create an icon right on that first page that takes you right to an electronic copy of your will, of your living will and healthcare proxy, so that if you find yourself at the hospital that isn't in your system, so they don't have it on record, you can just pull that right up.
That is a great idea. Rosemary, would you just take a moment, unmute yourself, and say what you said earlier when we were talking before about joining organizations in order to create more connection?
Well, I do think that some people, say, are new to a community and they don't really know people very well. And you could, if you're a senior, you can always join the senior center, and you'll find other people in the same situation as you are. Or you can join a religious organization, you know, a church or a synagogue or a mosque or whatever suits you in that way. Or in your apartment building, you sometimes can develop friends that way. And particularly if you have a group of people your same age, all of them are going to have these problems. And you might swap back and forth. I'll be yours if you will be mine. And so you can kind of work out some situations that way, I think.
Great. Thank you very much. I want to thank all of our attorneys today for joining us and answering all of these questions. I know there are so many more questions that got answered today than that got answered today. We could go on for quite a bit longer. It's a very large topic. We will make sure, if you didn't notice the handouts that I sent out already, look at those reminder emails that I sent to you. There will be a follow-up email, as I mentioned earlier, with the PowerPoint, and I'll put all those documents in the follow-up email again, as well as contact information for folks. One way to create connections is through the Living Well Network. That's one of our goals, is to help people to connect with each other. I invite you all to come walk on Friday with us at 10:30 in the morning. We'll be coming up with other opportunities, including book groups and drop-in sessions, and when we're able to meet in person again, some social events as well. This has been a very hot topic in our book group on aging, which some of you might be interested in. But again, I want to thank all of you for coming today. I will be sending an email out to everyone, and you'll be able to get in touch with me or any of our attorneys. So Rosemary, Sarah, and Jen, thank you so much for presenting today. And thank you to all of our participants.
Thank you.
Thank you, everyone.
Thank you all.